Good afternoon, ladies and gentlemen. I thank you all for joining us. As you all are aware, the South African Bar Association on a weekly basis hosts a speaker to deal with a legal topic intended to assist with training and development, which feeds into the core values enshrined within the South African Bar Association. These sessions are made available to inter alia young practitioners, students, and members of the legal sphere both locally and internationally at no charge. Before I begin, I would like to address a few housekeeping rules pertaining to the session. By way of reaping the full benefits of the session, all participants shall be muted until the question and answer session commences, whereby you will simply unmute yourself. In the alternative, you may type your question within the chat section, and Denise shall pose those questions to the speaker. Denise, you shall facilitate for such.
Yes, AJ.
Thank you. Today's speaker is no stranger to us, in a sense that he has been an advocate since 1997 and has been a senior counsel since 2014. Apart from his numerous appearances in the High Court, he has in addition appeared before the Supreme Court of Appeal, the Constitutional Court, and high-profile cases within Switzerland, in matters ranging from criminal and labor law on the one hand, to the judicial independence of the Magistrates Court and the constitutionality of municipal rates on the other hand. By way of naming a few of the matters he has appeared in, and I reiterate, a few of the matters he has appeared in, as if I were to list them all, I am adamant that this session shall continue through the night. He has appeared before the Constitutional Court in the case of the State versus Manamela, which many of you would be familiar with, as this case dealt with the constitutionality of Section 37(1) of the General Law Amendment Act. Further, he has appeared before the Labour Court in the case of Shishango versus Minister of Justice and the Constitutional Development, which yet again many of you would be familiar with, as this case dealt with whether information provided to the media constituted a protected disclosure under the Protected Disclosures Act. It is indeed a privilege to welcome the Honorable Advocate Garth Hulley, SC, who will be speaking on a timely and very important topic about the importance of observing court etiquette. I must confess, Garth, when Bart told me that your address would be surrounding the importance of court etiquette, and in lieu of the fact that you are currently the evidence leader in the commissions of inquiry into state capture, I was and still am highly strung. Without further ado, I now hand it over to you, Garth.
Thank you very much, AJ. Thank you so much for that very generous introduction. Perhaps a little bit too generous, because I must correct you on one thing. I have not appeared in Switzerland. In fact, I think it should be Swaziland, in the High Court of Swaziland. Subject to that, let me get into the topic at hand and the importance of observing the rules of etiquette that apply to our profession. Let me start first and foremost by identifying what we intend or what we speak of when we speak of something called etiquette. Now, the dictionary defines etiquette as being the custom or rules governing the behavior regarded as correct or acceptable in social official life. The second definition is it's a conventional but unwritten code of practice followed by members of any of certain professions or groups. Now, traditionally, up until fairly recently, when a code of conduct was introduced, these rules that had been applied were largely loose rules, and they were rules which applied with reference to specific societies. So in the case of the Johannesburg Bar Council and the General Council of the Bar, their rules were in fact written, and in some instances those rules could be applied as grounds for misconduct should people not follow them. But those rules were often applicable only to the specific society that applied and were often not observed by, or were sometimes not observed by members who belonged to other bar councils or to other institutions that had associations of advocates. In recent times, of course, much of this has all been overtaken because of the Legal Practice Act. And the Legal Practice Act, pursuant to Section 36, I believe Section 36(1), is under a duty to prepare a code of conduct which would govern the practice of law by the different practitioners, be they advocates, be they attorneys, or be they candidate attorneys. In some instances, there are rules which even govern those people who are none of the above three, but we needn't get into any of that for the present purposes. Section 36(2) says that the code of conduct serves as the prevailing standard of conduct which legal practitioners must adhere to, and failure to do so constitutes misconduct. So it's not a simple case of an unwritten rule that might have existed in the past and which one has to comply with to be regarded as socially acceptable standards. These are rules which now, if there's a breach of those rules or non-adherence to those rules, that would constitute misconduct. And in those circumstances, there could be proceedings that are brought against the person who has breached the rules, and that person could be held to account for his breach. Now, given that the code of conduct has directed what we are to do, and there is a code of conduct that was published, I believe, in 2019, and it seems appropriate that I should draw attention to the code of conduct. Every once in a while, I will refer across to what we refer to as the Red Book within the Johannesburg Bar Council or the General Council of the Bar, or specifically to the uniform rules of practice of conduct or etiquette that governs us pursuant to the GCB rules. And I do so because it was those rules that actually informed the legal practice code of conduct. So you'll see in many instances that they are almost identical. In some instances, they are, in fact, you can get insight into what the thinking was in relation to the code of conduct's provision when compared with the source of that rule, which was, of course, the Red Book, if you like. So what I intend doing is to first take us through the different rules and to have a brief discussion about each of the different rules, explain what the purpose is behind it in some instances. In other instances, the purpose is self-evident. There may well be some debate about whether such rules should in fact be rules or whether they're acceptable rules. But that's a debate that I will leave for the question and answer session towards the end. I'll simply explain the rule for present purposes. Now, the first one, and I suppose the most important one, concerns the appropriate dress. Now, in terms of clause 36 of the Code of Conduct, it says simply that counsel shall dress appropriately when rendering services to or on behalf of a client. Now, it doesn't identify or tell us where, in what circumstances those might be, except to say that it's when rendering services to or on behalf of a client. So that would theoretically include how you are to dress even in chambers when meeting with a client. In other words, when performing services or rendering services to that client. But of course, it goes way beyond that, and it includes how one should dress when you're before certain tribunals. Now, for the purpose of your dress in chambers, I think in many instances that's largely a matter of personal choice, but there are limitations to that. Those limitations may be imposed in terms of the group that you're in, or in terms of the society to which you belong. As far as I'm aware, there's no particular dress sense that is imposed by by the Johannesburg Bar Association, and I'm not aware of any other bar association that imposes a rule as to how one should dress for purposes of chambers. And of course, it would differ from client to client. Some people may have, you might be consulting with a client that is a corporate client, in which event you would dress in a suit and tie if you're a man, or in a suit or appropriately attired for a woman if you a female counsel. And if you were, for instance, consulting with certain clients in the construction industry, typically my experience has been that they tend to dress down, they tend to dress with jeans and that sort of attire. And of course, one can also dress appropriately having regard to that client. But more importantly for our purposes is the type of dress that you would have when you are appearing in court. Now, what the rules discuss is, firstly, we've got to be concerned about how to robe and in what circumstances to robe. And that's something that obviously concerns many junior people who are appearing, who are pupils and are appearing for the first, after taking, being admitted to the bar. They've got to decide or to know how they are to dress before different tribunals. You're appearing for the first time before a magistrate, you'll be appearing for the first time in the High Court, you may be appearing before certain water tribunals or a range of different tribunals. Now, the rule, as far as the rules of the Bar Council are concerned, say the following. Counsel should robe before the Constitutional Court, the Supreme Court of Appeal, the High Court, the Water Court, the Income Tax Court, the Court of Commission of Patents, the Special Court of Appeal against decisions in terms of the Maintenance and Promotion of Competition Act, the Land Claims Court, the Labor and Labor Appeals Court, all other courts and tribunals of a status similar to the High Court, and such other tribunals as the Bar Council may direct. For your purposes, as a rough guide, one can accept that whenever you appear before a judge, you must be attired in your robes, and I'll get into in a moment. I'll get into what robes there should be, and what your other dress should be like under the robes in a moment. But whenever you appear before a magistrate as counsel, you never robe before a magistrate. Understand that there's a movement underway which will require us as counsel to appear before magistrates with robed as well before the magistrates. As far as I'm aware, that movement is still in its nascent stages. It hasn't yet evolved to a point where it's become a rule. But that's the position as things currently stand. Then, in relation to what is to be contained beneath the robes, the uniform rules of court, or rather the practice manual, should I say, of the WLD stipulates the following. And I haven't looked insofar as the other courts are concerned, what they have, but I do know that similar rules apply across all the divisions. It says the following: counsel is required to be properly dressed. If not properly dressed, they run the risk of not being seen, in inverted commas, by the presiding judge. A proper dress for junior counsel comprises a black stuffed gown, a plain black long-sleeved jacket and not a waistcoat, which has both a collar and lapels. The jacket must have for closing 1 or 2 buttons at the waist, and the buttons must be black. A white shirt or blouse closed at the neck, a white laced jabot or white bands, dark pants or skirt, black or dark closed shoes. Proper dress for senior counsel comprises a senior counsel's silk gown, a senior silk waistcoat, a white shirt or blouse closed at the neck, a white lace or white bands, dark pants or skirt. Black or dark closed shoes. Counsel must ensure when appearing in court that their waistcoats or jackets, as the case may be, are buttoned up. And it is not proper for counsel to enter court not fully robed as set out above. It follows that counsel should not robe in court. And then, of course, for those who are inclined to wear any jewelry, there's a specific provision in that to that effect. It says that conspicuous ornaments or jewelry should not be worn. And when attending a judge's chambers during the hearing of a case, counsel must be dressed as set out in the preceding paragraphs. And on attending a judge's chambers otherwise than during a hearing of a case, counsel must be dressed as follows: a white shirt with a tie, that's for men, or a white blouse closed at the neck for women. They must wear dark pants or a dark skirt, as the case may be, a long-sleeved dark jacket, and black or dark closed shoes. Now, you will, of course, have observed that there are many counsel who appear with jackets that are, in fact, waistcoats. And as you can see from the practice manual, that's actually not acceptable conduct. And strictly speaking, the judges can actually call you to order for that. And in some circumstances, I've actually seen a judge give a dressing down, pardon the pun, to one of our colleagues for wearing a waistcoat during nothing more than a trial advocacy session. The week after the trial advocacy session had concluded, this happened on the Saturday, the week afterwards, there was a memorandum that went around to the entire Society of Advocates advising them that such conduct would no longer be tolerated in courts. Now, moving on then to the other rules relating to the etiquette. Clause 61.4 says that upon a first appearance before a judicial officer, legal practitioners should approach the registrar of that judicial officer, if the judicial officer is a judge, or the equivalent official in any other court, before the hearing in order to present themselves to the judicial officer. The rule is applicable to acting judges as well, and any prior professional or personal acquaintance with the acting judge is irrelevant. Now, it's become a rule in recent times because of the code of practice that you should introduce yourself also to an acting judge. In the past, it was considered to be improper to try to introduce yourself to an acting judge. But that's been overtaken now as a result of these amendments to the code. Then 61.5 says, at the trial roll call, in the motion courts and in divorce courts, legal practitioners shall seat themselves from the front row with regard to seniority. This was one of those rules which was certainly in existence prior to the Code of Conduct coming into effect, but was not regarded, I think, was not regarded as being one of those rules which could lead to charges of professional misconduct. That obviously has changed under the present rule. And one of the difficulties, obviously, that confronts the more junior members is to try and remember or to recall where you fit in terms of the pecking order. So when we started out or when I started out certainly as a much more junior member, there was a useful rule of thumb. The rule of thumb was you can accept that you're the most junior person and just consider it right at the back of the court. Don't bother, don't speculate about where you fit in terms of the pecking order, and you can accept as a given that however senior or junior the other members in court might be, that front row is reserved for senior counsel and in some instances for very senior juniors. But for the more junior members, you just don't sit in that seat, irrespective of whether there are more senior members in court or not. The rule, of course, was never that only senior counsel could occupy those benches. But effectively, it evolved into that because of the difficulty of ascertaining where the more junior members fitted in the pecking order. So now the rule actually is that it's reserved for the senior counsel. Then 61.16, point 6 says, legal practitioners shall deal with the judicial officer, court staff, and all other persons in court with civility and with respect. Now, this is a rule that hardly requires any elaboration, but it certainly requires emphasis because one discovers quite frequently that there are people who appear before judicial officers and quite frequently treat the judicial officer in a way which might be considered to be demeaning, and also treat other staff members in a similar fashion. The most important thing to be, well, quite apart from the fact that it happens to constitute misconduct for the purpose of the code of conduct, one must also bear in mind that it's a reflection both upon yourself, your case, and your client, because you're there to represent not only your client, but you represent also yourself. And importantly, you also represent the profession. So if you conduct yourself poorly in relation to whether it be towards the judicial officer, whether it be towards his registrar, or whether it be towards a court orderly or anybody else, you give a very bad impression of yourself and of course of your client whom you represent. 61.7 says that a legal practitioner shall, on the completion of his or her matter, remain in the courtroom until the legal practitioner in the next matter has risen, or if the legal practitioner is the last legal practitioner in court, until the court has risen. Now, a practice has developed, especially I've noticed in the labor court, where counsel, upon completing their matter, say to the judicial officer, to the judge, might I be excused? And almost invariably, the judge responds by saying, you may be excused. Now, strictly speaking, that's not in accordance with the code of practice. It's not in accordance with the etiquette that I grew up in, and it ought not to be tolerated. There's no need to request the opportunity to be allowed to leave. You will simply do so in accordance with the rule. That means that once your matter has completed, you will sit down and you will wait for your opponent, sorry, you will wait for the next person in line to rise. Once that person rises, you too may then leave. The importance of this rule is, of course, in circumstances, and I'll add a slight caveat to this rule in a moment, but the importance of the rule is to ensure that there's as little disruption as possible, and that when the focus of the judge particularly turns to the next counsel, it's at that point in time that you can basically leave. It's out of respect for the bench and out of respect, of course, for the other member who would stand to his or her feet to address the bench. There may be circumstances, and this is the caveat, where you happen to be in line with the conversation. In other words, you sit in somewhere between the judge and your colleague who stands to his feet to address the bench. You might be immediately in front of him, or you might be 2 or 3 rows ahead of him, but directly in line of their eye contact. In those circumstances, I would go so far as to say that you remain seated, even if your colleague, even once your colleague stands, once you discover that that is the case. And you remain seated until such time as the attention of the judge is moved to another person who is not directly in line with that, with the contact between the two of them. That's, of course, once again, out of respect. You don't stand up when somebody else is speaking. If it would interfere with their line of vision and the trajectory of their voices. Then the next one is 61.8. Sorry, and if I could say one further thing before I leave 61.7. With regard to standing up or to remaining in court, and if you're the second last counsel in court, the purpose of that stems from the notion of retaining the independence of the bench. So counsel must not be left alone in court with the judicial officer, so that the impression or the air of independence is maintained. So that's the reason why you're not supposed to leave court while another colleague is still addressing the bench. And above that, of course, or together with that, is of course a sign of respect to that colleague, that you will remain in court so that you can afford him the opportunity of addressing the court while he or she still has an audience. 61.8 says the following: a legal practitioner shall not, when briefed in an opposed matter, approach a judicial officer in the absence of the opposing legal practitioner, unless the opposing legal practitioner has expressly agreed thereto. As a general rule, try to avoid it at all costs. There may be circumstances in which you require an audience with the judicial officer and you can't get hold of your opponent. Your opponent might be running late or something to that effect. You'll make every effort to get hold of your opponent. And if for whatever reasons, and there might be circumstances in which the judicial officer may call upon you to meet with him or her in chambers. And it might be that the judge or the magistrate is himself or herself unable to get hold of your opponent and insists that you should attend at his chambers. In those circumstances, what you would do is you would always make sure that you attend in the judge's chambers together with the judge's registrar or a clerk, and make sure that you attend also together with your attorney. So you will never meet alone with the judge or the judges, with the judge or the magistrate, as the case may be. What you will do is that when your opponent eventually does arrive in those circumstances, you must give your opponent an indication, or you give him a thorough, detailed account of what transpired in chambers, what was said, who said it, etc., so that your opponent is informed at the earliest opportunity of any issues that may have arisen in chambers. And also, of course, coupled with an explanation as to why it is that there was a need to meet with the judicial officer without him or her being present. But as a general rule, to the extent that you can avoid it entirely, you will not meet with the judicial officer without your opponent. 61.9 says that legal practitioners shall not allow any ill feeling between litigants or legal practitioners to interfere with the civil and professional conduct of the matter. Now, this requires a little bit more explanation. And if I can refer to the Red Book on this, so you can get some insight into the source of this rule. Paragraph 4.12 says the following: clients and not counsel are the litigants. Whatever may be the ill feeling existing between clients, it should not be allowed to influence counsel in their conduct and demeanor towards each other or towards suitors in the case. All personalities between counsel should be scrupulously avoided. In the trial of a cause, it is improper to allude to the personal history of all the personal peculiarities and idiosyncrasies of counsel on the other side. Personal colloquies between counsel which cause delay and promote unseemly wrangling should also be carefully avoided. And of course, coupled with that, I think even if certain things are said in jest, they should be avoided at all costs. But there's an importance about what is said over there and in the Red Book, and that is that you are there to represent a client. You are not there to represent yourself. So whatever your relationship might be with your opponent, it should never manifest in court. You might be, and of course, on the other hand, I mean, and the obverse to that is that your relationship might in fact be a good one. But that in itself, neither must that impact upon the way in which the matter gets conducted. The matter must at all stages be conducted with a certain level of aloofness from your opponent, independence from your opponent. You mustn't be overly friendly towards your opponent. That doesn't mean that you can't be civil, If you have a personal relationship, whether it be friendly or whether it be otherwise, that relationship must not manifest in any way in the court proceedings. Even during adjournments, you can be friendly towards each other, but as friendly and as civil as you would ordinarily be to any other opponent. Obviously, if you don't have a relationship with the person, it would be very difficult to be overly friendly with that person. But that is the same level of courtesy, respect that you must show even to somebody who is a friend or is not a friend. There should be no distinction in that respect. Then the next rule is rule 61.10. It says that legal practitioners shall not indulge in personal remarks about opposing legal practitioners or witnesses, whether in court or out of court, and shall not allow any antipathy that might exist between the legal practitioner and the opposing legal practitioners personally to intrude upon the conduct of the matter. Now, of course, this rule applies both to what happens in court and to what happens outside of court. So when you're in the corridors, quite frequently you might feel a burning desire to express certain views about your opponent, negative views, but you must restrain yourself in that respect, and you certainly don't allow those views to bubble over into the actual court proceedings itself. If you've got a difficulty with your opponent, and sometimes one does, and depending on the nature of that issue, that's something that must be dealt with in private. It's not to be dealt with in the corridors of court. It's not to be dealt with in the court proceedings themselves. I've seen some very senior counsel actually engaged almost in a physical fisticuff with each other. So bad had the situation become. Now, it seems to me that the judicial officers should intervene long before something rises to that level. But sometimes the judicial officers are themselves wary, A, because they don't want to be reported themselves to the Judicial Service Commission, which seems to be something that's on the increase at the moment, and B, because they feel reluctant to engage with counsel because they're afraid of how things might pan out. But if you experience that, whether you're the victim of it or otherwise, as counsel, you should raise it at the first opportunity with your bar counsel, and subject to what your bar counsel has explained or said how the matter should be dealt with, you should then refer it to the appropriate body to have it investigated if there has been any, or if you believe that there's been any misconduct on the part of an opponent. And that includes even if you're present in court and you witness something of that kind taking place. Your duty doesn't end only where you're dealing with your opponents. Your duty includes how you deal with the other people, other practitioners who are in court at that point in time. 61.11 is very important, and we see it arising all the time. People just don't know what the rule is. Well, it's now been laid down in black and white, and it says that after a hearing and when a judgment is awaited, a legal practitioner shall not place before or try to send to a judicial officer any further material of whatsoever nature, except by agreement amongst the representatives of all parties, provided that if consent is unreasonably withheld, the placing of such further material may, in an appropriate case, be the subject matter of an application to reopen the hearing to receive it, or if the further material consists only of references to authorities which might offer assistance to decide in a question, a legal practitioner may address a request in writing to the judge's registrar or equivalent court official to approach the judicial officer with an invitation to receive the references. A few years ago, I appeared in a matter in the Supreme Court of Appeal where I advanced a particular argument. And after I returned on the flight back it occurred to me that there was a problem with my argument. My argument was in fact wrong. It was both legally, well, it was legally unsound, and that I should not have advanced the argument. So when I got back to chambers, I approached my opponent, and suggested to him, requested him to allow me to approach the court with a request to withdraw that portion of the argument and to explain why it is that the argument was being withdrawn because of its, because, as I put it, it was legally unsound. My opponent agreed to it. I also approached the Bar Council and asked the Bar Council how I should deal with the matter. The Bar Council said that I should approach my opponent, which I had already by that stage. And subject to that, there was nothing further that needed to be done other than to place the representations before the court. Now, this was not a case where I was seeking to advance new argument for the purpose of advancing my client's case. It was in fact the opposite. And after I had put the argument in with the leave of my opponent then took it upon himself to then respond to my argument. And his intention was not to actually withdraw anything that he had said, but rather to build up on a case which had never been advanced. It wasn't in any way addressing anything that I had said. I consider this to be quite improper. As it so happens, I didn't take the matter any further, but I did consider it to be quite improper. And that's not the way in which one has to conduct yourself, or one should conduct yourself. What in more recent times, I happened to come up against an unrepresented opponent where a similar situation arose, where additional legal argument needed to be advanced after the matter had been fully argued. We approached the unrepresented person, who were actually people, suggested that what should be done. They objected to further evidence being handed in. We then put in a full application on notice of motion together with an affidavit explaining why it is that this further evidence, it wasn't further evidence, further legal argument was being advanced. As it so happens, I mean, the judicial officer concerned, it was in the labor court, the judge concerned considered this to be quite inappropriate, said as much in the judgment, and refused to accept the additional legal argument, then handed down a judgment which conflicted with what I had advanced in the legal argument. And we took it on appeal to the Labor Appeal Court. And of course, we won on the very issues that we had raised in the further legal argument. Then 61.12 says, a legal practitioner shall not deliberately seek to catch an opposing legal practitioner off guard. Accordingly, and it sets out some 5 subparagraphs, whenever a legal practitioner has prepared heads of argument other than when compelled to do so in terms of the rules of court, he or she shall not later than the time when the heads are presented to court also give the opposing legal practitioner an identical set of such heads. There was an old war joke that was told about a particular counsel who would hand up, because of this particular rule, would hand up not his heads of argument when he appeared in court at the same time that he handed up the heads of argument to the judge, but would hand up 1 page to the judge and 1 page to his opponent. Now, that strikes me, it certainly would seem to be improper under the present, the present iteration of the rule. But my view was that it was improper even under the old rules, because the whole purpose of legal argument is to present an argument which your opponent has an opportunity to fully address. The purpose is not to catch your opponent off guard, as the rule now articulates. And that was always the case, that you're not there to try and catch your opponent off guard by presenting an argument which you understand or which you presumably fear might be incorrect. And if your opponent had sufficient opportunity to consider the argument, would be able to reveal why the argument is incorrect. So be careful of that. I think that you need to bear in mind that your obligation is to represent your client and to ensure that in representing your client, you do so to the best of your ability. You obviously want to win and your client wants to win, but you mustn't do so at all costs. And you mustn't do so at the cost of coming across, if not dishonestly, at least sailing as close to that description as you might consider permissible. You should always be upfront with your opponent, and whatever you say, and this is perhaps not a rule of etiquette per se, as opposed to a rule of ethics, but whatever you say must go. That is, sorry, must be your word. So if you say something, it must be so. And you must know it to be so. If you don't, if you're uncertain about what it is that you're saying, if it's a factual matter, then express it as such. I'm not entirely certain about the answer to that, my lord, my lady. But my recollection is the following, and then you'll tell the court what it is that your recollection is. In the next subparagraph, whenever a legal practitioner gives a bundle of authorities to the court, he or she shall also give at least a list containing the authorities to the opposing legal practitioner. Now, I'm not so sure of what context this has been spoken of. If it's a bundle of authorities that's been handed up at the actual hearing for the first time, then I would hazard to suggest that you must, in those certain circumstances, also provide a copy of the bundle of authorities. It's not good enough to simply give a list. How is your opponent to make use of the list? So we can see that there's 5 cases that you've mentioned. That's not good enough. If you're handing it up for the first time at the actual hearing, then you must make a bundle of the authorities available to your opponent as well. If you were handing it to him a day or 2 before, then it's not necessary for you to make the bundle of authorities available, but the list will suffice. Whenever a legal practitioner makes use of a transcript of proceedings, he or she shall give the opposing legal practitioner a copy no later than the first time that reference is made to the transcript. So if the transcript is referred to in your heads of argument, you should attach a copy of the transcript to the heads of argument. If it's referred to in any other form of written address, it should be included in that written address. Next subparagraph says, whenever a legal practitioner is intent on taking a point of law not evident from the papers, independently of any rule of court that might apply, he or she shall notify the opposing legal practitioner in good time to avoid that opposing legal practitioner being taken unawares. So as soon as something occurs to you, it's a legal point that has occurred to you, and you've worked up the point to a level where you believe that you intend to take that point in court. You must immediately contact your opponent, advise him or her of the intention to take the point. And if you've expressed your point in writing, because there might be certain points that are difficult to appreciate without being in a written form, if you've written up the point, you then send that off to your opponent. In some instances where you intend to take something like an exception, you contact your opponent beforehand, before you take the exception. If you've drafted up the exception, you send a copy of your unsigned exception to your opponent and tell your opponent, this is the exception I intend taking and why it is that I intend take it, so that the opponent has an opportunity to address the issue before any litigation flows from it. And then whenever a legal practitioner intends presenting the court with an unreported judgment, he or she shall, in advance of the hearing, notify and give a copy of the judgment to the opposing legal practitioner in good time to avoid the latter being taken unawares. Of course, these are always subject to the exigencies of the case. So there might be, if you're in an urgent matter and you come upon a unreported judgment, you make it available to your opponent at the earliest opportunity. But if the earliest opportunity is at the hearing, then you hand over a copy of that of the judgment to your opponent, the unreported judgment to your opponent, together with an explanation of the aspects of that judgment that you intend relying upon, so that the opponent has the opportunity to A, consider what it is that you intend referring to, and can do so by reading through the rest of either the head note or the rest of the judgment, in order to determine whether what you are saying is in fact correct. I've certainly had the occasion to, when I've been presented with an argument plus an unreported judgment. After having read through the judgment, it came to my, it became clear to me that my opponent wasn't citing or wasn't quoting the judgment correctly. There were aspects of the judgment that contradicted exactly what my opponent was advancing. So one has to be cautious of that, because the impression that you create, should you do that, is that you've been dishonest, that you advance in something that is to your knowledge not correct. I see that it's 16:45. AJ, how much further, how much more time? I think I'm probably at the end of my address. Is there anything, do I have any more time?
Look at, do you want to, is there anything else that you want to go further with?
Just to say that when one encounters situations where there's been any misconduct on the part of an opponent, on the part of your on the part of somebody else that you've seen on court, how one should go about addressing that. Raise it first and foremost, before, especially if you're more junior, raise it first and foremost with one of your more senior colleagues. So don't go and complain about every single thing that happens to occur to you. Raise it firstly with a more senior colleague. And if the senior colleague is uncertain, or if the senior colleague believes that he or she doesn't know the answer to the issue that has been raised, then you can take it up with somebody even more senior. But ultimately, it's important, it's imperative that in order to maintain the standards of the bar, that you should raise these issues with the bar council or with the head of your institution.
Good. Denise, is there any questions that we have from the participants? Denise? Denise? Right, I think we've lost Denise there. Is there any questions from the participants? Could you just kindly unmute yourself and ask her?
Hi, Garth.
Hello.
It's Lee.
Hello, Lee.
I have a question about, actually two questions. Do you need instructions from your client to withdraw an incorrect argument? Or do you just need to inform your opponent that you want to withdraw an argument that you made that was legally incorrect? That's the first question. And then the second question is, when you need to introduce yourself to a judge that you're appearing before for the first time, and your opponent is late and you can't get hold of him, what should you do? Do you introduce yourself without your opponent present, or do you run the risk that the judge is gonna crap on you as well for not coming to introduce yourself? Those are my two questions.
Okay. Typically what I would do, so one must distinguish between my advice and what I think is necessarily the correct position. But my advice would be that any argument that I intend presenting, I always try to present that argument to my client and advise my client about the strengths and the weaknesses of a particular argument. Sometimes, and you may well think that because your clients happen to be lay people, that they don't have insight into a particular legal argument and therefore they can't provide you with any assistance. That's in fact, my experience has shown that that's in fact not true at all. Lots of clients have, even if they don't have a legal background, have a sense of what is correct and what is just. So it's useful actually to run something by your client just for that purpose. But obviously, legal argument ultimately is for counsel to advance. It's not for the client to make any final decisions as far as that's concerned. My experience has shown that the clients would have insight at a factual level. So they'll tell you, well, but that's not correct at a factual level. But to answer your question directly, Lee, where you've decided that there's a legal argument that needs to be abandoned, that decision is yours alone. You would obviously have to run it by your client to say, I've advanced this previously. For the following reasons, the argument is wrong. I intend to withdraw that aspect of the argument. And you run it by the client. The client, of course, has the option of saying to you, look, I don't want you to withdraw it. But if you got to that, then you're really facing the end of the relationship with the client, because if the client insisted that you should not abandon it, then you've got to withdraw from the matter altogether. Now, of course, that might be cold comfort insofar as your ethical duties are concerned, because at that stage, there is nothing more that needs to be done. By definition, you already argue the matter, and that all that remains is for the judgment to be delivered. So that's a very unusual situation. And my advice to anybody would be to first seek advice from somebody higher up, and hopefully from the Bar Council itself. And once you've got that advice, you'll act in accordance with it. But my view would be that if the client refused to grant you that permission, that you should then notify the client that you intend withdrawing from the matter for that reason. Insofar as your second question is concerned, Lee, what you would do is you would raise it with the judge's clerk in the first instance, because you never approach the judge except through his or her registrar. So you would say that I wish to introduce myself to the judge, and my opponent has not yet arrived. My intention is, or my inclination is, to wait until my opponent has arrived. But so unless the judge wishes to meet with me without my opponent, I will wait in court until such time as my opponent has arrived. What the judge's clerk or the registrar might have a view based upon past experience of how the judge will deal with the situation, and may then express that view, or may go and seek guidance from his or her judge, and then bring that information back to you. Once that happens, of course, you'll act in accordance with it. But the best way to do it is to first raise, you don't go off to the judge of your own accord and then tell the judge when you get to chambers, my opponent hasn't arrived, and therefore I thought I would approach you directly. You first give it to the registrar and let the registrar deal with the situation.
Okay, thanks, Garth. Sorry, I just have one more, then I'm done, I promise. It's regarding etiquette when a judge engages you on a hypothetical scenario that isn't relevant to the matter specifically. Sometimes I've seen counsel decline to engage, and it tends to upset the judge. So the judge will ask a question, but put it in a hypothetical, and it has no relevance to the matter or to both counsel. It doesn't seem as though it has
relevance. Well, at least in your view.
But to both counsel, it would seem like it doesn't have any relevance, but the judge engages you to answer the question. Sometimes I've seen counsel decline and the judge insists, and they persist with declining, and other times counsel actually does engage and gives a caveat that of course they haven't really applied their mind, it's not relevant, and they don't want to prejudice their opponent in the event that the opponent also the opponent elects to decline to engage the judge. How does one handle a situation like that?
Well, I think obviously the first thing is, to make the assessment of whether you consider something to be so utterly devoid of proper consideration. It's just so completely removed from the facts of your case or from the legal issues that have arisen in your case. But I don't think that there should ever be any circumstances in which you should decline to answer a question. The judge has, sometimes the judge just gets it completely wrong. And I've sat as a judge of the Labour Court and as a judge of the High Court on sufficient occasions to know that that this is absolutely true. But if the judge gets something wrong, you've got to address, you've still got to address the question. And the best way to deal with it is to say at the outset, what I understand your question to be directed at is the following issue. Now, I'll address your question in two ways. I'll address it firstly with reference to head on and explain why I say what I do. And secondly, I'll explain also why I believe with respect to yourself, my lord or my lady, why I believe that this issue is actually not relevant. But let me start off with the first issue, and then you'll get in. So you deal with the judge's question head on.
Yeah.
What frequently happens is that counsel avoids answering a question, either because he doesn't know what the answer is, he or she doesn't know what the answer is, or because they believe that the question is irrelevant. And then, of course, it becomes, the entire debate becomes very strained after that. And what the is in effect saying to the judge, not directly, but certainly implicitly, is I think you're an idiot, and I'm not going to answer your question. Now, you're dealing with human beings, and bear that in mind at all times. You are dealing with a human being. So, and you're trying to advance your case, the strongest case for your client. Any human being would take offense to being called an idiot, either expressly or implicitly. And what sometimes happens, it shouldn't happen, but sometimes what happens is that the judge, it may affect the outcome of the case. I would think that most judges would be unaffected by that, but that's not to say that there aren't some judges who may well be affected by it, even if it's inadvertently, without unconsciously, the judge is affected by it. You've got to make sure that you always address the bench with respect, as you should your opponents and every other staff member, as we've already gone through.
Okay, thanks, Garth.
Okay.
Denise, is there any more further questions?
Hi, Garth.
Hello. Who's that?
Turning on my camera. I don't know if you recognize me.
Well, if I could see, I would perhaps decide whether I can recognize you or not. Who's speaking?
It's Nerisha Naidu. You know me from the DPP's office.
Oh, how are you?
I'm good, and you?
Yes, very well.
I'm now with Ribonia Group of Advocates.
Okay.
But my question to you is, now that there's more individual bars coming up, like the SA bar and Pabasa, how do you determine seniority in motion court, the more junior members?
Well, my advice is a simple one. Obviously, when you're dealing with, if your matter has been called according to seniority, then you need to know the answer to that question with some degree of certainty. And usually the people that appear, because these issues obviously arise in the context of unopposed motions, as opposed to opposed motions, which get allocated to specific judges, and they'll be called in accordance with the order that the judges have determined. So there, no difficulty arises so far as opposed motions are concerned. Insofar as unopposed motions are concerned, you, not always, but generally, you'll find that the counsel who appear in those matters would tend to be counsel between, from about your middle junior range to your baby junior. You tend not to find more senior counsel than that, except on, with exceptions. But it won't be a regular or a frequent occurrence. Now, the better rule to apply is, so the judge calls for seniority on the page.
Commissioner, I'm listening to a little bit of the last bit of this talk. Is done now, whilst we're waiting.
Sorry, somebody else speaking.
Sorry, Bart.
Yeah, it was Bart.
Sorry, Bart. Can you please repeat that?
So,
apologies, Garth. I'm just saying thank you. Sorry, I couldn't follow most of the presentation. Thank you for everything that you guys have done. And yeah, AJ will close. Thank you for your assistance as always and your eloquence.
Absolutely. So I hadn't finished answering that question.
Please
Shall I
do,
finish?
please do continue, Gert.
Okay, so obviously what you would do is you would generally know from within your own bar who's more senior, etc. Even that can be difficult in a bar that's the size of ours. But you you look at the person's age and try to make an assessment of the person's age as well. And that's the way in which I would do it. But that's one of those rules which I would say is simply a rule of etiquette. It hasn't yet escalated into a rule that forms part of the code of conduct. So, and I'm talking about the seniority in terms of call-in matters. Seniority in terms of how you appear, which benches you occupy. Now that's on a different level. That clearly has been made part of the rules of conduct. But in those instances, as I've said, the best rule to follow is that you don't occupy the first two benches. Place yourself as far back as possible, and then count based on the number of years of experience that you've got. If you've had each year, you move yourself forward one bench at a time, so that by the time you've been at the bar for about 12 or 15 years, when it doesn't really matter, you should be when this issue of seniority doesn't really matter any longer, you should be close to the front two.
Thank you.
Pleasure.
I must apologize for getting you to come to our offices, not knowing that you were senior counsel at the time.
Not at all. I needed the documentation, as you'll recall, and therefore it was imperative that I should attend there, not the other way around.
I'll refrain from that in future.
Don't worry about it. Don't mention it at all.
Thanks, Garth.
Absolutely.
All right, Garth, firstly, Garth, relating to the Switzerland-Swaziland error, by way of justifying such error from my end, I quote Harvey Mackey's quotation, which reads, "You can't buy a good reputation, you must earn it. From your experience and your address this afternoon, you have indeed earned your good reputation. Accordingly, I trust that you shall accept my apology in that regard."
No need to apologize. I just didn't want to accept any greater glory that I deserve.
If there's no further questions, I think the only thing that remains for us is to thank Garth for your time, and we would like to obviously have you over sometime in the near future yet again. By way of conclusion,
Absolutely.
thank you, Garth. Thank you so much for your time, and thank you all for the thanks to the participants for all of their time as well.
Thank you very much, AJ.
Thank you.
And thanks for the.
Thank you. Thanks. Cheers.
Okay. Bye-bye.
Bye.
Thank you. Bye-bye.